If you bring a lawsuit against your careless doctor, will the defense be allowed and permitted to ask for and to see your tax returns? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you believe that your doctor was careless and caused you significant harm and injury. An expert, a medical expert, confirms that your doctor violated the basic standards of medical care, causing you significant harm and injury. Now your attorney goes ahead and starts your lawsuit. And now you're concerned that during the course of your lawsuit, the defense is going to ask for and they will be able to see your tax returns. Now what's the big deal? Number one, you're a really private person. You don't tell anybody about how much you were earning. Everything's above board, everything's good and kosher with you, you have no issues with your taxes, but you just don't want to disclose that to anybody. You know that the only people who are supposed to see your taxes are your accountant and the IRS. That's it. You don't disclose your income to your family members, to your best friends, to your cousins, to your relatives. You don't do that, and you've never done that. But now, during the course of your lawsuit, you are worried, you are concerned that some stranger, an attorney who represents the doctor whom you have sued, might request copies of your tax returns, might have an opportunity to review your tax returns, and, more importantly, during the course of your deposition in your lawsuit, during a question and answer session, that he will ask you extensive questions about what you put in your tax return. And now you're concerned. You don't want anybody to see those things. Not that you did anything wrong. You feel like you're being violated, or potentially, if the defense lawyer will be allowed to go ahead and ask you questions about your taxes and about your income and what deductions you made. And you're worried. Can the defense lawyer go ahead and do that? Well, in order to answer that question, the first question I have to ask you about that is, okay, as a result of the injuries that you suffered because of this careless doctor's actions, did you lose income? Were you out of work for a period of time? If the answer is yes, then the question is, okay, how much income did you lose? And if in fact you did lose income and you lost money as a result of the doctor's carelessness, and now you were disabled for a period of time and were not able to return to work, then the answer is yes. Okay, now you have to figure out exactly how much money you have lost up until the present time. If it's a substantial amount of money, now we will include that as one of your claims of damages in your particular case. In these various civil lawsuits involving medical malpractice or accident matters or wrongful death matters, we include many different claims for damages. We include claims for pain and suffering from the time of the wrongdoing up until the time that you no longer have the problem. Now, there's past pain and suffering, and there's future pain and suffering. What is the suffering you are likely to experience into the foreseeable future? That's only one element of damages. Then there's something called pecuniary loss or financial loss to the family. Let's say it's a death case. Now we have to look and see what was the amount of money that this person who died was bringing into the family. And because this person has died, what is the financial loss that this family has now suffered? So in that instance, it's critically important to understand whether they were earning a living at the time, if so, how much, and what they lost as a result from a financial standpoint because this person is no longer alive to provide financial support to their family. Let's assume for a moment that yes, you have financial loss. You were out of work for a period of time, let's say 2 years, as a result of the injuries you suffered. In that instance, we are going to include that claim as part of your damages. When we do that, how does the defense know that what we are claiming is true? How do they know, other than us saying that you lost, let's say, $300,000 during the course of those 2 years? How do they know that what you are claiming is true? We have to support that claim with actual documentation. And how do we do that? It's actually pretty simple. We go ahead and get your employment records. We go ahead and get your W-2 forms. Let's say you were working for a company and now they issued you W-2 forms. In that instance, we can show, okay, here's exactly what you were earning in year 1, here's what you were earning in year 2, and now here's what you were earning in year 3. And now you can see the progression of you increasing the amount of money you were receiving in each one of those years. And obviously, if you can no longer work, now we can say, had you continued working, look, this is what you would have expected to earn over the next number of years. What happens though if you were not working for a company, but you were self-employed? Now, how do we show to the defense the amount of money that you lost because you were self-employed? One of the only real ways that we can do that, other than testimony from you about the type of work you were doing, how much money you were receiving, what type of jobs you were getting, is by showing them your tax returns. Your tax returns are hopefully going to accurately depict and show your income level during each of the previous years. And the whole purpose of that is to give the defense an opportunity to see and to confirm that yes, this is exactly what you were earning, and because you were unable to work over this number of years, yes, we understand now. This is exactly how and why you claim you lost all of this income. So let's get back to the bigger question. Can the defense ask for your tax returns? To answer that question, we have to ask you whether you were self-employed or whether you were working for a company. You see, there's a difference. If you are self-employed, you're not getting a W-2 form every year. Instead, you have to fill out your tax return and submit it to the IRS. If you are self-employed, we have to give copies of your tax returns for 3 years prior to the date of your malpractice or the wrongdoing. That's the difference. If you were employed by a company, we only have to provide W-2 forms, and the defense would only be permitted to look at and to see and to ask you questions about what's contained in the W-2 forms. If you're self-employed, now they have a bit more leeway to go ahead and ask you details of what's contained in your tax returns. So let's jump back for a second again. You are concerned about someone who is a stranger to you, who now is looking at critically your tax returns. And you're afraid, you're concerned that they're going to pick apart and dissect and try and criticize your deductions, criticize what you've claimed. And you know what the reality is? Yes, they are going to look at it critically. They're going to go through it with a fine-tooth comb and now ask you questions about it. And they want to do that in order to confirm whether what you have claimed is accurate concerning your lost income. That is the goal. You see, when you bring a lawsuit seeking money as a form of compensation against a doctor who is careless, against a careless driver, against a careless homeowner, a landlord, whoever it is, now you put your condition in issue. And what does that mean? It means that from a physical standpoint and the injuries you suffered, the defense is entitled to learn about all your physical disabilities, about all the problems you had from a physical standpoint. Your medical condition becomes an open book now. And now the defense can properly ask you many, many, many questions about your past medical history and about your current physical limitations, because you have put your medical condition in issue, and they need to confirm that what you have said is true and accurate. That is why the defense attorneys are permitted and are allowed to get copies of your medical records. They are permitted to go ahead and try and talk to your treating physicians, to learn from them exactly what problems you have today, to learn what disabilities you have. And the same thing applies to your tax returns. If you are claiming lost income and you are self-employed, yes, the defense is entitled to probe and to learn and to examine whether or not what you have claimed in your tax returns are accurate. If for some reason they are not accurate, now they can show discrepancies between what you are claiming you should be receiving and what you have claimed in the past. Why do I share this quick information with you? I share it with you just to open your eyes to what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I recognize you likely have questions or concerns about your own matter. If your matter happened in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.